Hi everyone and welcome to the YouTube channel of Get Set Law by IMS. I'm your mentor Sanjana Chauhan and this video again is in continuation of the previous two videos. In the first video, I discussed the first passage of CLAT 2024 English language section. The second video was on passage 2 under the English language section. And this video, we'll be discussing the third passage under CLAT 2024 English language section. Right? So let's start discussing the passage here. Now this passage, if I have to describe the tone or the theme of the passage, it essentially is a socio-political commentary on the state of justice as is prevalent today across the globe and particularly with the focus on India. Right? Let's start reading it. The crisis of justice, that is the subject matter of discussion today in the media, is in fact the crisis of justice for the middle class. Right? It's already given in quotation, which means this might be of some significance. Expanding on the same, the author writes further that the main difference between India and the OECD, which is the Organization for Economic Cooperation and Development countries, is that whereas a middle class OECD countries have reasonable access to justice, in India, it does not have. Later on, a vocal and powerful middle class has emerged in India since 1991. So now the author is essentially focusing on the contemporary era starting 1991 in which a vocal, a very vociferous or a demanding powerful middle class emerged. Since then, it is demanding reasonable access to justice. Much of the judicial reform effort will help meet this demand. So, about the fact that justice for the middle class, which at some point seemed a distant idea in India, the author does have some sort of hope and expectation that it will improve given how the middle class has now become quite demanding and quite vocal about its needs, interests and requirements, right? Now, let's focus on the second paragraph. Now, the author shifts the focus on not justice for the middle class, but justice for the poor. The question of justice for the poor is, however, an altogether different challenge. Every single time in all of my videos, if you just go through it, I keep reiterating a very basic point. Always pay attention to the buts and the howevers given in the passage. They introduce something very surprising or some contrary fact in the passage, which can be of crucial importance here. So no country in the world has been able to secure justice for the poor. So it's not just something which is limited to India, as one might infer, but it's something which is a global phenomenon where the poor have not been able to secure or access justice. Now, why this happens is, let's just start reading it. Most of the jails, not all, most of the jails of the richest countries are filled with the poorest. The masses are more often victims of the criminal justice system than of crime. So it's not, so as is generally the case, people might be victim of crimes. But here, people are the victims of criminal justice system. In that, they find it very difficult to have access to the justice systems here. Right? Now, again, the author shifts the focus on India. In India as well, jails are almost exclusively filled with the poor. Right? The civil justice system is hardly accessible to them. So this is point number one. It's rendered as, disadvantages that are prevalent amongst the Indian criminal justice system for the poor. Right? And then apart from this, the justice system is hardly accessible to this. This can be your second point here. Why? They are often victimized by lawyers, touts and court staff. That's point 3. Their docket excluded a new type of untouchability. Now, for a lot of you, if you might not have some background knowledge of what docket exclusion is, it essentially refers to the practice where petitions of the poor people are not really listed. This is perhaps done to avoid the burdening of litigation on the courts, right? But then again, if the petitions are not being listed, it does not really help the poor, especially the poor, to have access to justice, right? So, the author has termed this as a new type of untouchability, right? Now, the language and the logic and the colonial and feudal culture of the judicial systems are alien to them. The language is also something which is alien to them. So, this is point number 4. It rarely takes cognizance of their needs and interests. So, their needs and interests are hardly looked after or cared for. This is point number 5, right? Let's take a look later in the passage. Their main concern, the concern of the poor, is to escape the attention of the justice system, which is both criminal and civil. Now, the author here quotes a landless Dalit person who gave the author an insightful definition of a court from the perspective of the masses or from the perspective of the common people. A court is a place where you're forcibly taken by the police to be punished. No one goes to a court, right? So what essentially the author is trying to emphasize through this statement is that how the common people have started to perceive the courts, right? It's not really that just as the very profession or the line of reasoning is, right? So in contrast, however, many lawyers and judges colloquially, in very contemporary terms, they define the court as a temple of justice where rights are protected. But this is in stark contrast to the situation of justice for the poor as is prevalent in India, right? So later on in the passage, again, the author is expanding on his views. These sharply divergent visions. What are the sharply divergent visions? So there's a certain segment of the population which possibly views courts as a temple of justice where rights are protected. And then there's the remaining section of the population who hardly feel that the courts care about their needs and interests, right? Protecting the livelihood of traditional taxi and, okay, again, there's this very important statement. These sharply divergent visions mean that justice for one section is often injustice for another. Now, the author is trying to offer an example of this statement where when something is done for one section, that act might be viewed as detrimental to the other section. For example, protecting the livelihood of traditional taxi and auto drivers from predatory pricing, which is practiced by corporate app-based taxi providers, by imaginatively using the available tools of law to delay their incursion, would be seen by the rich and the sections of the middle class as a failure of the judicial system, because it brings down the ease of doing business, right? However, the masses, again, for the commoners here, this would be seen as this judicial intervention will be viewed as a very strong evidence of a good justice system. Finally, that justice is being meted out to them, right? Although the conflict over competing visions, so this is very crucial here. The conflict, which means justice and the system of justice as is present in India, is very conflicting, in that what might be justice for one section might amount to injustice for the other section, right? Although the conflict over competing visions of the nation and conflicting demands from social and economic segments, right, have confined judicial reform of judicial administration mainly to neutral areas. So the term neutral areas here implies areas where no conflict can have the potential of, developing, right? Areas such as process reform, which is neutral to everybody. So if you bring about some sort of improvement there, this is just an example to help you understand the passage better. If you bring about some improvement, some sort of decision in such a neutral area, this might not adversely impact most of the people, or this might be viewed as something which is beneficial uniformly across all the segments of the population, right? So what are these neutral areas? Process reform, procedural law, technology, planning, court and case management, judge strength and the workload of judges. There has been considerable improvement in the neutral areas and the judicial system has improved its performance. Now, overall, if I were to just draw some inferences about the judicial reforms in the judicial administration of neutral areas, the author is having a very positive tone. We kind of appreciate the improvement that has been brought about it. However, if the entire judicial system or the entire justice system has to be viewed by the author on a very general level, the author feels it's very conflicted, right? And there's a lot of selectiveness that is being emphasized through the usage of some words, right? So what might be justice for one segment might amount to injustice for the other section. So this is all that the passage is about. It's a very typical socio-political commentary on the state of justice. And the writing style is also quite analytical in nature, all right? Because the author has also expressed his 2 cents on the issue. Now let's start discussing the questions. First question. What is the central thesis of the above extract? It's always helpful to first look at the options in such questions. Option A. The practice of untouchability takes various forms in modern India. So far, untouchability has only been used in a very metaphorical manner to talk about docket exclusion of the poor people. Not that it forms a part of the central thesis. It is not the central thesis, right? So we can clearly eliminate option A. B says, The imagination of justice for the rich and poor is vastly different. Multiple times in the passage, the author has emphasized the conflicting demands amongst the different, sectors or segments of the society. And this so far seems like a very strong and important option for our question here. Let's just look at C and D. Addressing judge strength in caseload management does not affect the performance of the judicial system. This is not a central thesis. We can eliminate this. D says protecting the livelihood of the traditional taxi drivers is contrary to the goals of ease of doing business. Now, this is just a statement which is not made in a vacuum. It's just expressed as a view of the author. And, it is contrary to the goals of ease of doing business is something which is only felt by a certain part of the society, not the society as a whole. And besides that being so, even though this might be some bit true in light of the passage, it is not the only thing, or it is not the main thesis that is being talked about in the passage. So we can eliminate D by default. B is a correct option, very much in alignment with the discussion so far on what the passage is about. Take a look at the 14th question. What does the author mean by docket excluded in the second paragraph? I already did discuss what docket exclusion is. Now, students might also feel that, ma'am, what if we do not have any background knowledge of, the phrase docket exclusion? It's still okay, because let's just look at the options. The only context in which the term docket exclusion is mentioned is that it just further contributes to how access to justice becomes a very cumbersome task for the poor people. And the fact that docket exclusion is being termed as a new form of untouchability. Okay, so based on this information alone, I believe students, if you're really confident about it, because confidence is key when answering the questions, right? You'll be able to arrive at the correct option. Look at option A. The poor do not have easy access to the justice system. Right? This so far seems like the correct option. Look at option B. Courts do not list bail petitions of poor under-trial prisoners who populate the country's jails. Now, you might be, ma'am, isn't that just the thing that you discussed about docket exclusion? Now, as far as solving and approaching English language, which is RCs, and critical reasoning is concerned, one very primary criterion we share with the students is to always stick to the data given in the passage and just try to avoid relying on your background knowledge. If you rely on the background knowledge and the very dictionary meaning of the term, that most likely the answer has to be B. But because we're advised to not rely on the background knowledge and just answer questions in context of the passage, this really helps us to know that A will be a better option than option B. It's not like B is incorrect. It's just that A in the context of the passage is a better approach for you to go by. Look at C, the poor reject the judicial system. Now, upon just a reading of this part itself, we know this is the incorrect option. It's not the poor rejecting the judicial system. The system of justice is the one that is rejecting the poor people. So C is incorrect. D says the rich are excluded from the country's prisons, which are mostly populated by the poor. This is incorrect information, very distorted at that. The correct option, therefore, will be option A. Option B is not entirely incorrect. Option A is better than option B. Sometimes you have to choose the better option. Keep this in mind. Okay? So, now let's discuss the next question. Which of the following words best describes the experience of different segments of people within the justice system? As described in the third paragraph, the word conflicting is already mentioned. This is the correct option. And so many times I've already, tried to hammer the point how the system of justice is very conflicting, right? Now look at A, symbiotic, which means mutualism, which cannot be inferred, right? It's very divided. It's very selective in nature. So we can eliminate A. Affective is incorrect. Interdependent is absolutely incorrect. Again, not given. Conflicting is the correct option for this question. You get 16. Which of the following statements is the author most likely to agree with? This is an inference-based question. I personally believe inference-based questions are quite easy to answer because you do not really have to do a lot of heavy lifting. You can simply start reading the options, go back to the passage and verify if that option can be inferred or not. Right? Look at A. The judicial system reflects the same power relationship as those that exist in society. We'll keep it on the side, this option so far, because it's very broadly worded, right? Look at B. Access to the judicial system is determined more by person's economic status, such as wealth and income, than by their social status, such as religion and caste. While the first part might be remotely inferred from the passage, the focus on religion and caste is not mentioned, and this makes the entire option incorrect. Keep in mind, just because a part of the option is correct doesn't mean the entire option is correct, right? This part is especially not emphasized in the passage. We can eliminate option B. Option C says the judicial system was made by the rich for the rich of the rich. This is very distorted. We can eliminate option C. Now, you might have a choice between A and D. A lot of you might feel that A is something that does not particularly ring a bell in your mind. But let's try to decode and understand A. The judicial system reflects the same power relationships as those that exist in the society. As far as the passage goes, our focus is very much on the axis of justice amongst the rich, the middle class, and the poor segments of the society, right? For the rich, it's not really that difficult, is at least what we can infer. For the middle class, the author has some hope that the justice system will improve. However, the author here has a very dismal view of the justice system and if it's accessible to the poor, right? So the way the power relations are functioning in the society is nothing, right? So essentially, as far as the passage goes, the power relations existing in the society are very much in tandem with how the judicial system also reflects those powers, right? The judicial system reflects the same power relationships as those that exist in society. This is something which is a beautiful inference. The way the society functions, there's a lot of gap, there's a wide gap, discrepancy between the rights of the rich, the middle class, and the poor. The judicial system works similarly along the same lines. For the rich, it might be accessible. For the middle class, the author has some hope, right? And for the poor, it's actually a very dismal situation, right? So correct option for this question will be option A. Take a look at the next question now. Which of the following statements is the author most likely to disagree with? Please read every question properly, word for word. We have to choose an option that the author does not agree with. Look at option A. A truly representative democracy would ensure that the interests of the poor are also represented in the judicial system. This is essentially the opinion that is being voiced by the author. And this is an option that he really agrees with. So this is something which we can eliminate because we have to choose at one option which is not really in line with the author's reasoning. Look at B. The law ensures equality both in text and in practice. Note how, practically speaking, the author is saying there's a lot of conflict in how the justice system is accessible to different segments of the population. While the law, as far as the text version is concerned, might be all about equitability or equality, right? But that is not the case. There is a wide difference. There is a stark difference between law in text and law in practical application. And therefore, this is something which the author will absolutely disagree with because there is a gap. It is not equal. It is not equal both in text and its practice, right? So this is the correct option so far. Look at C. The poor suffer most at the hands of lawyers and touts compared to judges who might still pronounce judgments in their favor from time to time. Look at this part. Can we, from anywhere in the passage, infer this part? Not at all. So this is incorrect. All right. The poor suffer most at the hands of lawyers and touts compared to judges who might still pronounce judgments in their favor from time to time. Right? And obviously, D cannot be the correct option. The correct option for this question will be option B. Take a look at the next question. What makes reform of judicial administration a neutral area? Option A. Persons across socio-economic strata agree on the need to reform judicial administration, right? So this is incorrect. This is not really addressing the neutrality of the areas under judicial administration. B. There is consensus amongst political parties across the ideological and regional spectrum on the reforms to judicial administration. This again does not address our question. We can eliminate this. C. Reforms to judicial administration do not favor one class of people over another. Now keep in mind that in the last part of the passage, the author emphasizes on how conflicting the access to justice system is amongst different segments of the society. For the poor, it's particularly very, problematic, while for the middle class, the author has some hope expectation that the justice system might improve for them. Therefore, much of the reforms in the, judicial area, in the field of judicial administration are restricted to some areas which are neutral, which means they do not really have a very selective approach. They apply uniformly across all segments. Isn't this just the very thing I did discuss while explaining the passage here? So if that is the case, C is the correct option. Reforms to judicial administration do not favor one class of people over another. This, by the way, students, is an inference-based question, right? Inference is an unstated conclusion. So this is something we can conclude from those statements given. D says reform of judicial administration is mandated by the Constitution. This is not mentioned in the passage. While realistically or practically speaking, this might be true, but again, we do not have to rely on background knowledge. Just stick to the data given in the passage. So D can be eliminated as well. Correct option will be C for this question. So yes, this was a discussion about this third passage. I hope you like the video. I hope you understand all the pointers that I have discussed. I hope these pointers come handy, and any doubts, any queries you might still have pertaining to these questions, you can always ask in the comment section, right? I'll see you in the next video. Stay tuned.